بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله على سيدنا ونبينا محمد وعلى آله وصحبه وسلم. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. Alhamdulillah, in our lessons on Mukhtasar al-Quduri, we are still in Kitab al-Nafaqat, on providing for one's dependents. So we reached وتفرض على الزوج نفقة خادمها إذا كان موسرا. It is obligatory, right? تفرض, it is required. I wouldn't translate here as obligatory. تفرض بمعنى تلزم. It is required. It's not necessarily in the meaning of it being fard here, right? تلزم. It is required على الزوج نفقة خادمها, to provide for a servant if the husband is financially capable. إذا كان موسرا. Now, from this, of course, it's understood that this is not required if he is poor. Right? The commentator mentions that, quoting from the Hidayah, right? And that is the narration of Al-Hasan from Imam Abu Hanifa. Al-Hasan meaning Al-Hasan ibn Ziyad al-Lu'lu'i. And this goes back to the general principle, which is that the husband has to provide for the wife in accordance with what is entailed by his financial state and her financial background. Like, what kind of household does she come from, right? And there's a big aspect of urf in this, of custom. Because even an upper middle class family in Canada, for example, do they typically have a full-time servant? No. Right? So can someone sitting suddenly, Sheikh Yusuf hears that according to today's dars, you have to provide for me with a khadim and this and that. Can that be demanded of you? No, because one has to see the financial state of both parties, and number two, the financial state of both parties, and what is entailed for them, hasba al-urf, right? According to the urf. And this is very important when it comes to the books of fiqh, because there's many ahkam that are built upon urf. Now, in the pre-modern time, for a long time, there was stability. And one of the mahasin of the Muslim world, that there was hundreds of years of social stability. That even when there was political instability and even sometimes economic instability, there was social stability. Right? And that's very significant. Right? So that broadly, we're not saying all over, there's no ideal age ever except in Jannah, but so that's very important to appreciate, right? So something like this cannot be taken as an absolute. This is إن كان العرف يقتضي ذلك. If إن كان حالهما مع رعاية العرف يقتضي ذلك. If their state, which is a principle from before, and custom, if it entailed that. ولا تفرض أكثر من خادم واحد. And it is not required to provide for more than one servant. Right? And this is the position of Abu Hanifa with Imam Muhammad. Abu Yusuf disagreed on this, but most of the authorities of the madhab went with the position of Imam Abu Hanifa, because he has to take care of providing for her needs, and her needs are fulfilled by one person, so she does not need two. And then he says, وَعَلَيْهِ. And now this is something that's neglected big time, and it's a source of a lot of conflict in many places. Now we're not going to go into the applied areas of this, but some of the ulama refer to this as the concept of al-bayt al-shar'i, right? يحق للمرأة بيت شرعي مستقل. It is the right of the woman to have a shar'i home, right? That is independent of other parties. That has many practical significances, right? Now, what is considered to be a bayt shar'i, right? An independent home, it would depend on what is the al-mu'tad, what is a normal home given their financial state. And if they got married at university, maybe just a studio apartment would be fine, right? But if he's a working professional and so on, according to what is their background and ability, but she has a right to a bayt shar'i, where she has her privacy in terms of where, her, like a bedroom, a living space, and a kitchen space, minimally. Right? Bedroom, living space, and a kitchen space. So he'll tell us that, right? وَعَلَيْهِ, we've taken alayhi means, that this is for a duty, right? It is upon him, على الزوج, أن يسكنها في دار مفردة, that he make her live in an independent home. Now, dar has a technical usage. Right? Has a specific sense and a general usage. The specific sense of dar goes back, have we talked about the three types of homes? There's three broad words for housing in classical Arabic. There's many, many words, but three broad words. You have a bayt, a manzil, and a dar. So classically, البيت ما يبات فيه. The bayt is where you sleep. So it would be like a room. المنزل ما أعد للنزول. A manzil is that which has been prepared for staying in. So a manzil would be like an apartment, right? They call it in Arabic a shukka, right? So it has what you need to live. Room, living room, maybe kitchen, maybe dining room, depending on how big the place is. What you need for that. That's a manzil. Like as if it would be like an apartment. And then you have a dar. A dar is ma yudaru alayhi al-hitan. It is a property around which a wall is built. So in the old sense, they would be like what we call al-bayt al-arabi, an Arab home. You go inside, it's wall, there's a corridor, and there's rooms all around it. That's a dar, right? In that sense. In other places, there'd be a home and would have a garden attached to it, a walled garden. There's different ways, but conceptually, there's three levels of homes. There's one usage of the term bayt, manzil, and dar, but they may also be used interchangeably. Here, right? Because words are not like equations. A plus B equals C. Okay? Here, that he يسكنها في دار مفردة, in an independent home. It's not referring to she has to have her own, like dar, like her own property, right? Where, you know, like there's a garden and this and that, because maybe they can only afford the little studio apartment, which is more like a bait, okay? Okay? Because that depends on financial state and the urf and all those things. And now she doesn't have to own it, and it doesn't have to be owned by him. Neither of those are considered. ليس فيها أحد من أهلها من أهله, in which there's no one of his family there. That's her right. إلا أن تختار ذلك, unless she chooses that, meaning unless she chooses to allow that. And this is one of the areas where there's a lot of social dhulm. Why? Because there's a saying from the Salaf that كل مال أخذ أو كل ما أخذ بسيف الحياء فهو حرام. That anything taken by the sword of shyness is prohibited. Okay? So imagine if, you know, Sidi Yusuf hasn't eaten all day. In the evening, he's got, you know, he's got a cheeseburger. He's starving. Someone comes and says, "Can I have that?" He says, "Okay, go." But he feels embarrassed to say no. So he goes hungry. That wasn't allowed for the person to do that. Why? Because it was given out of shyness. Right? لا يحل مال امرئ إلا بطيب نفس منه. Right? No one's wealth is permitted except with their طيب النفس, willfully. But the same applies to all other rights as well. Right? So someone concedes, okay, they can stay, but they felt coerced. And that's the part of the haqq that is very difficult to, that was it بطيب نفس منها? Is it of her outward and inward willingness? Right? So it requires the rida. And we'll be seeing when we come to fiqh of transactions that إلا, Allah subhanahu wa ta'ala says, لا تأكلوا أموالكم بينكم بالباطل. Do not consume one another's wealth falsely. بالباطل. إلا أن تكون تجارة عن تراض منكم. Unless it be through trade on the basis of إلا أن تكون تجارة عن تراض منكم. On the basis of تراضي. This is تفاعل. Right? From mutual agreement between you. This is called مبدأ in modern legal terminology. مبدأ التراضي, the basis of mutual agreement. It applies, the عبارة النص, the expression of the text relates to, in the verse, to tijara. But the same concept applies بالدلالة, by indication, to all other dealings related to rights between two parties. That any time there's rights involved between two parties, you can only seek something that's rightfully another's on the basis of taradi. And isharat al-nas, by the indication of the text, that all dealings have to be on the basis of, not even just transactional, but others, there's taradi. You can't force one. Right? So let's say we have a female teacher here, she gets really enthusiastic. So she goes on the street and gets all Muslim women she sees that come attend the dars. They all come out of, not bit taradi, but because they felt that, okay, this lady told us to come, and they feel pressured into it. That's the isharat al-nas, that's not allowed, right? And this is this mabda of taradi, and the person having the rida, Well, if you look in the chapter, it'll be coming in Mu'amalat on when someone can be prevented from transacting because they're foolish in their financial transactions. Abu Hanifa said once they reach 25, just give them their money, even if they deal with it foolishly. Why? Because منعه عن التصرف إهدار لآدميته لسلب الاختيار. Because preventing them from transacting is a negating of their humanity, because you're depriving them of their choice. Because there is a choice, that this choice is an amana. And as Allah tells us in the Quran, إِنَّ عَرَضْنَا الْأَمَانَةَ عَلَى السَّمَاوَاتِ. We offered the trust, and that is the capacity to choose, to the heavens and the earth. فَأَبَيْنَا أَن يَحْمِلْنَهَا. What? أَشْفَقْنَا مِنْهَا. The heavens and the earth? No, we don't want it. Like, وَإِيش? The human being took it on. But that's what makes us human. لَقَدْ كَرَّمْنَا بَنِي آدَمَ. We have honored the children of Adam. This is a very serious matter, right? And of course, practically, it leads to a lot of disputes. Now, we have a number of answers related to this, but unless she chooses that, but بِطِيبِ نَفْسٍ مِنْهَا, of her goodwill. A lot of societal bad customs related to this in many societies. Okay? So if the woman is asked, in terms of tawjeeh, we encourage her, are you willing to accept this? Within reasonable bounds. Right? His mother is sick. Does she have to take care of her? No. But for a few months, etc. If she willfully does so, we encourage her. Do it, you have great reward, etc. But we cannot say, do it because you have to take care of his mother. No, you don't. Shar'an, this is not correct. And right, so this is important. But at the same time, we don't use these limits. You know, it's important to distinguish between where the limits are and where the akhlaq arises. We also have to be clear, and when we give people choices, that this is what is your right, and this is what you are encouraged to do. Because you cannot take what is a recommendation into an obligation. So that's delicate. Okay. وَإِن كَانَ لَهُ وَلَدٌ مِّنْ غَيْرِهَا. There's another problem that happens, sadly. You know, many, with a lot of divorces and people having partial custody and so on, this causes problems. Even if he has a child from other than her. So, Zubayr married Zubaydah in their older age. They're both 45 when they finally got married. Zubayr had previously married Lubna. But then Lubna died. For a car accident or whatever. Lubna left little Salwa. So Salwa is with Zubayr. He said, okay, my daughter Zubaydah loves me, she'll accept Salwa as well. Does Zubaydah have to accept Salwa into their home? No. I have a right to Bayt Shari. فَلَيْسَ لَهُ أَن يُسْكِنَهُ مَعَهَا. It is not his right, it is not the husband's right to demand that his child from a previous marriage live with them. Right? Because providing for housing for the wife is an obligation upon the husband. Right? He must provide it, he may own it, but she has a right to her independence in it. Right? And they consider لأنها تتضرر به, because having a shared space is a harm for her. That's the nature of the woman. She needs that security of her private space. Okay? And however, okay, if there is separation in the house between them, So for example, if there is a townhouse kind of thing, and the parents or child from previous marriage, whatever, is in the basement, for example, etc. So that, and there are rules set so that they set certain spaces that the person doesn't need all the times could be shared, such as kitchen, for example, right? Right? So that would be reasonable, right? That goes into issues of fatwa and so on. But in our times, for example, someone's living in a townhouse. If his own children comes and they stay in the basement and so on, it's very conceivable for people to stay even for an extended period of time in someone's basement. But very manageable, right? So, Allahumma salli. Okay. So this is the limit. What is reasonable is, should be considered, but the practical thing that we also need to instill is in these kinds of challenging situations, consult the people of knowledge and the people of wisdom. Okay. وللزوج أن يمنع والديها وولدها من غيره وأهلها من الدخول عليها. Just in terms of pure limits, it is the right of the husband to prevent her parents and her children from another marriage and her relatives from entering upon her, meaning in the house that he is providing for her, right? Because that manzil, that home, belongs to him, and he has the rights of ownership over it. But this is in terms of just limits. لا يستحسن ذلك, that is not good إلا لسبب, unless there's a reason. They are causing harm to her or to him or to the relationship, right? Or to the children, etc. That should not be done. Right? And then Ibn Qudama, one of the great Al-Maqdisi, one of the greatest of the Hanbali jurists, the author of Al-Mughni, says practically there's certain things where when things come to rights, she wants to see her parents, he says no. At my house. She says, I want them to come. He says no. Ultimately, they have to figure out how to have al-mu'ashara bil-ma'ruf. They can live together in good, because otherwise, marriage cannot last. Then, the fuqaha put a principle, إِذَا فَاتَتِ الْمُعَاشَرَ بِالْمَعْرُوفِ فَالسَّبِيلُ الطَّلَاقِ. If you can no longer live in good, then the only way forward is divorce. عَاشِرُهُنَّ بِالْمَعْرُوفِ أَوْ فَارِقُهُنَّ بِالْمَعْرُوفِ. Live with them in good or part in a good way. Right? So sometimes there's some things that are your right, but if you exercise both demand their minimum right, then there'll be a bit of a gap. Right? Why? Because it's like your right and her right, there'll be a gap in the middle, which is what? Just وَجَعَلَ بَيْنَكُمْ مَوَدَّةً وَرَحْمَةً. He has placed between you love and mercy. Some of the ulama said, is as if your rights and the other person's rights leave a gap between you. How do you fill that gap? Like what's a cement that puts the blocks of the relationship there? Mawadda wa rahmah. There has to be some care. And mawadda is caring, love. Okay. Rahmah goes back to concern. Right? Concern for good. If there isn't that, then ultimately that gap will just widen. Anyways. So these are not suggestions on good practice. It's just in terms of exercise of right. It's like someone enters your house and you notice they're picking their nose. You could tell them, could you please leave my house? Right? Because you don't want your kids to see things like that. But you have some guests come over, and then you decide, see Hamza, get out of my house. Is it my right to do that? Is it? And I said, please. Can I say that? But is it the right thing to do? To kick someone out? Of course not. But then if I did that, can you hold it against me? That's also one of the tricky things in the Sharia. You cannot hold something against another that is not your right upon them. Right? And few people judge by the Sharia when it comes to their rights. ولا يمنعهم من النظر إليها وكلامهما في أي وقت اختاروا. But one does not prevent them from looking at her and talking to her at any time that they wish. So that is from breaking family ties. Right? Right? And there are a few opinions on this. So you cannot, the underlying principle that is agreed is that he can prevent them from entering his house. Should not be done unless there's a good reason. But he cannot prevent them from maintaining a relationship with her. So the old days would be that she stays home. One thing is to look at her. So from the window, they come and visit and they talk from the window, for example. They open the door and they're talking, but they don't come inside. Not exactly virtuous conduct, but... Or there's a number of other opinions, right? Among them is that it is not his right to prevent her from visiting his parents, right? Nor can he prevent them from visiting her at her residence on a weekly basis. So once a week, cannot prevent her from either visiting them or for them to visit her. And this is the final of the opinions that is mentioned in the commentary. وَقِيلَ لَا يَمْنَعُهَا مِنَ الْخُرُوجِ إِلَيْهِمَا. So, and it is said that the husband cannot prevent her from visiting them, وَلَا يَمْنَعُهُمَا مِنَ الدُّخُولِ عَلَيْهَا, and cannot prevent them from visiting her في كل جمعة, each week. It's not each Friday, but meaning من جمعة إلى جمعة, right? On a weekly basis. وغيرهما من المحارم التقدير بالسنة, and other immediate family would be on a yearly basis, and this would return. And again, this is a taqdeer مبني على العرف. Right? This is a hukum that's built on urf. What is considered reasonable visitation depending on where you are. Right? وهو الصحيح, and this is a sound opinion as mentioned by the Hidayah. Right? The call is he cannot, but the most important line, he cannot demand that she break relations with her family. But he has a right to prevent harm on their relationship, on the children, or harm for her. Right? But at the same time, if his safeguarding his rights is causing her harm, she does have the right to seek divorce as well. Okay. Now what if someone, we've looked at the rulings of providing, what if someone can't provide? So he says, وَمَنْ أَعْصَرَ بِنَفَقَةِ امْرَأَتِهِ لَمْ يُفَرَّقْ بَيْنَهُمَا. If someone is not financially able, right, becomes financially unable to provide for his wife, the qadi would not separate between them. لَمْ يُفَرَّقْ, meaning لَمْ يُفَرِّقِ الْقَاضِي بَيْنَهُمَا. The qadi would not separate between them. So the wife goes to the qadi and says, my husband is not providing for me because he's unable to. The qadi would not say, okay, I will make this fasq would be, this tafriqa, separating between them would be fasq. The qadi would not just automatically annul the marriage. وَيُقَالُ لَهُ, rather the qadi would, because the general case, what happens? The husband has to provide fairly. If she doesn't agree with the providing, they have to come to an agreement between themselves. Right? But here she's saying he's not providing for me. He is in a state of i'sar, right? Of financial difficulty. He became financially incapable. So the qadi would specify a nafaqa. This is how much you have to provide on a monthly basis. Figure it out. Given your circumstances, you may have to borrow, you have to go find a job, whatever. وَيُقَالُ لَهَا, but he's not able to. So, poor guy. وَيُقَالُ لَهَا اسْتَدِينِي عَلَيْهِ. Says, seek to borrow on his name. So Zubaydah goes and says, Shaykh Zain, can I borrow $1,000 and Zubayr will pay you back because I need groceries for the next 3 months. So Shaykh Zain lends her the money, but who has to repay it? Zubayr. But this can only be done through the qadi. Because otherwise, the woman borrows money and said, okay, my husband has to pay it back. No. Okay. Okay, so this has to be only from the qadi. Now, what if the husband disappears? He travels for a long time, he's not provided. So he tells us, وَإِذَا غَابَ الرَّجُلُ وَلَهُ مَالٌ فِي يَدِ رَجُلٍ وَهُوَ يَعْتَرِفُ بِهِ. If the husband is absent, and usually this means غيبة سفر منقطعة, right? It's absent through travel and is منقطعة such that he's not readily expected to be back, any time. And her husband has money in the hands of somebody who admits that this money belongs to the man who's absent. So Zubayr went on a long trip. He decided to go on da'wah for 400 days without any digital technology. Right? It's a no-tech Jamaat, NPJ. Okay? So she can't contact him. So what happens? And this man who has the money belonging to the person who's traveled, he admits that this money belongs to Zubayr who's traveled, وَبِالزَّوْجِيَّةِ, and admits to this woman being the person's wife. He can take a risk. Now, if he gives the money, let's say Zubayr travels, so Zubaydah goes to Shaykh Zain, says, Shaykh Zain, remember you borrowed $2,000 as part of your walima for my husband? Say, I did. Said, could you pay it to me? Now you're taking a risk. If you were to pay Zubaydah, you're paying her because Zubaydah is not Zubayr. Just in terms of legalities. So if you paid Zubaydah just off your own accord, Zubayr came back and said, give me my money. With the adab and so on. I paid your wife. Zubayr said, I spent it. Who owes whom money? Okay. You owed Zubayr $2,000. Zubayr traveled. Zubaydah goes, asks you for the $2,000. You paid Zubaydah, she used the money. Zubayr comes back and says, I need my $2,000. Who has to pay Zubayr? You have to. Unless Zubaydah establishes that she has permission from Zubayr to take the money on her behalf. Now you want to safeguard yourself. you'd like to pay her. You know how Zubaydah is, and you'd like to help Sister Zubaydah out. By that time they got married, they're 45, we call them Auntie Zubaydah. Right? So, what do? You go to the Qadi. Right? So the Qadi says, yes, Zubaydah needs the money. You've got money that belongs to Zubaydah, give it to Zubaydah. The Qadi, so everyone has rights. Right? Everyone has rights. No one can take their rights from another unless there's agreement. Right? So imagine if I go to Shaykh Yusuf's house, or Shaykh Yusuf comes to my house, I owe him $100. So he says, let me see. I'll take the pour over, that's $25. I'll take this book, that's $50, $25 left. Okay. Tells his wife, let's take 6 cups. You can't do that. So, well, he owes me $100. You can't just do it on your own. Okay? You have to ask. You cannot take your rights from another. Because you don't have wilaya over another. Except in exceptional circumstances, which will come in mu'amalat. So when you seek your right from another, and they're not giving it, then you either come to an agreement, or a settlement, or you have to take it to court. But you cannot just take your right from another. Generally, there's some exceptions to that, which is the dhafr bil mal, right? But that comes up in financial transactions. So in that case, فرض القاضي في ذلك المال نفقة زوجه الغائب وولده الصغار ووالديه. You have an alif missing in the commentary. ووالديه. Right? So there the qadi, this person who has another's money in their hand, the qadi would specify that from that money, the wife has to be provided for, the child of the absent person has to be provided for, the small children, not the adult children who can provide for themselves, and for the 2 parents if they are in need. Right? ويأخذ منها كفيلا بها. But the qadi takes a guarantor regarding this wealth, right? Just to safeguard everyone's rights. Right? And there's processes. How is this done? Because the court, Sheikh Zain can't say, okay, you go make payments to everybody. The qadi they establish a process of how this money is handled, and that's a procedural matter. Okay. ولا يقضى بنفقة في مال الغائب إلا لهؤلاء. And no provision is specified in the wealth of someone who's absent for other than these: the wife, the small children, and the parents if they are needy. And there is some detail related to this, but we don't need to get it. It's a procedural detail. We won't get into it. And then, normally, the duty of the husband is to provide in a manner that fulfills our haqq. And that's ada'ul haqq. It is recommended to provide bil ma'roof, in a good way, and it's virtuous to provide bil ihsan, with excellence. And we talk about 3 levels of right fulfillment: ada' al haqq, ma'roof, fulfilling the right in a good way, the ma'roof, and above and beyond that is with bil ihsan, with excellence. At 3 levels. But what if if he doesn't do that, she demands the rights, they come to an agreement, great, they come to just a mutual settlement, that's great. They could go. So in general, how are rights fulfilled? Willfully or by mutual agreement. And so, you know, we can start with mutual agreement, then with just mutual settlement, then through mediation, then through adjudication, then through court. Right? Adjudication is tahkim. Right? Tahkim. If they agree on someone to rule between them, that should not be done in a place where there's a good legal system in place. But tahkim, even in Muslim lands, is often required because the court systems are either corrupt or non-functional or slow. So they can't come to an agreement. It may be that they need to go to court to see, okay, how much do you have to provide for the person? And in this, if you want to look at Canadian law, for example, the legal system here has guidelines. And you just Google it, so that if there's, and it applies especially in the case of divorce and so on, that how much you have to provide for, how much child support you have to provide. They have schedules, depending on, similar thing, depending on his financial capability. That's how much he has to provide for the children. Okay. So the Qadi, it returns to the Qadi's judgment, and in many Muslims, historically, they would have schedules of how much, if he makes this much, has it, like their different backgrounds, their financial status, how much he has to provide. But the Qadi has to be just and strive to be objective in his rulings. So وإذا قضى القاضي لها بنفقة الإعسار ثم أيسر فخاصمته تمم لها نفقة الموسر. If the Qadi specified for her the provision, the nafaqah of someone in a constricted financial state, إعسار, ثم أيسر, then he became of better financial means. أيسر, this could be either, أيسر could either be خرج عن العسر. Right? أيسر, then he had yusr, and the yusr can be relative, which is just الخروج عن العسر. هذا يسر. And he left عسر, left financial difficulty. Leaving financial difficulty is a type of ease. Or they can be كامل إيسار, or complete ease, where he went from financial difficulty to being in an actual financial capacity. He became ذو سعة, someone of expansiveness. فلينفق ذو سعة من سعته. That the one who has expansiveness provide from their expansive. ومن قدر عليه رزقه فلينفق مما آتاه الله. Let them provide from, let them spend from what Allah has granted them. Same thing applies in the context here. Then if she takes him to court, that you only have to provide because you had restricted means, but now you have more, فخاصمته. Then she opposes him, meaning in court. The khusuma is when she takes him to court, and they're in opposition to each other. It's called khusuma. تمم لها نفقة الموسر. Then the Qadi completes for her the provision of the one of expansive means. Now, what if he's just, Zubayr didn't provide for her for 3 months. Zubayr is a total nerd. He got some new books and he's been reading them. He forgot to provide for his wife. She was really patient, decided to fast every other day, and then decided to do other dramatic things and so on, being patient. Then she got fed up. She opened some fiqh books, saw, I have loads of rights. Didn't read all the details, read the things she wanted to read. So went and said, you owe me 3 months of nafaqah. He's been reading a lot too, right? So, says, إذا مضت مدة لم ينفق الزوج عليها فطالبته بذلك فلا شيء لها. If a period of time passes in which the husband does not provide for her, and then then she demands from him for the past months of provision, she doesn't have right to that provision. Right? Because let's say he didn't provide for her in September, October, November. December, she says, you didn't provide for me for September, October, November. But, yeah, what do you have to provide? Food for that time, housing for that time. The time's gone. So how can I provide for you for housing at that time? Zubair had to feed her at that time. The time's gone. So how am I feeding you for that time? He has to what else? Provide for her clothing. Hopefully she wasn't unclothed at that time. But even if she was, he can't clothe her for that time because the time's passed. Time does not come back. Now if she wanted to take a debt on his behalf, then purely legally, at least in court, she should have sought legal provision for that. إلا أن يكون القاضي فرض لها النفقة, unless the qadi specified how much is rightfully hers. Because his money is his, she cannot just take it like that. Now, diyanatan, religiously, there may well be a case, the fuqaha differ on this, and that if she took on debt, for example, if she took on debt, especially if she took on debt externally, to the extent of what he is expected to provide for her, then diyanatan he should repay her. But if she spent her own money, then that was her choice. But those things get very tricky. أو صالحت الزوج على مقدارها, or she makes sulh. She comes to a settlement with her husband on how much he owes her. But she says, look, we better agree to something, otherwise I'm taking to the court and this and this and this and this and this. Can we come to a settlement? And this is very interesting. Coming to a settlement, Allah subhanahu wa ta'ala says, as-sulhu khair, that coming to a settlement is good. Imam Abu Hanifa took that as a mutlaq hukum, as an unconditional hukum. So even if someone's making a false claim against you, you are rewarded for coming to a settlement with them. They would be sinful for making the false claim, but it is better to make a settlement than to continue the dispute. And Imam Shafi'i disagreed with this. He said, as-sulhu ala al-batili batil. Right? Coming to a settlement on the false is itself false. That's not necessarily his exact words, but so sulh is a good matter. Right? If you can come to a settlement, is better than the continuation of argument. وإذا مات الزوج, if the husband dies, بعدما قضى عليها بالنفقة, after the qadi determined how much provision, support is due to her, ومضت شهور, and many months pass, and he hadn't provided for her, and he's dead now, سقطت النفقة, those months of provision dropped from her. Why? Because she should have demanded them as the provision became due. You delay it, the money still remained in his hands. When he dies, what was his property goes to his inheritors, right? But again, there's a janib of ihsan. The better thing would be for them to come to an agreement with her. Now, many people would marry and travel, right? Because much of the Muslim world, and certainly a lot of Arabia, was quite barren. And certainly the Arabian Peninsula itself, it's different, like in Iraq and Persia, the Persian land. But many parts of the Muslim world were quite barren, so people would travel. Travel takes time. The trade routes would often take time. So often husbands who were God-fearing and careful about their rights, they would provide for their families for the duration of their travel. All the journeys would take a long time. So وإن أسلفها الزوج نفقة السنة ثم مات لم يسترجع. If the husband gave her in advance the provision of a whole year, because the provision kicks in stage by stage, right? So you could make an argument that he provided for a year of provision. Zubayr gave Zubayr, he said, I'm going for my 400-day non-technical, whatever, his long dawah trip. Here's a year of nafaqah. Where she blows it, he doesn't have to provide any more to her. Right? He gives it to her, but he dies, poor guy, in month 3. Can his inheritors demand 9 months worth of nafaqah back? No. Because the ownership of it had transferred to her, right? According to what's in the method, right? لم يسترجع, one cannot seek return of any of it back. Right? Because provision is a type of maintenance of relationship. Right? It's a sila, it's a maintenance. That's what it's actually called in English, called maintenance. It's a sila. That you maintain. And now she's taken possession of it, so it enters her property. Right? And silat, and things that are given as a sila, as a maintaining of relationship, they're not taken back after death. There's other examples of that. وقال محمد, right? يحتسب لها نفقة ما مضى وما بقي للزوج. Imam Muhammad said that they calculate how much belonged to her of the months that have passed, and the rest was still the husband's. So, if the husband dies, then what happens? It enters into his inheritance. So if a God-fearing woman, what she would do, if she's given a nafaqah of a sana, she shouldn't say, well, let me spend it and then let's see what happens later. Because if the husband comes back early, the cautious thing is to consider that only what the time that passed, that became rightfully hers. Everything else, her yad in it, is a yad of amana. Now, the purpose of mentioning other legal opinions is not only to say, okay, this is relied upon, that's not, but to be able to exercise caution. Right? And caution is exercise. The ruling is الخروج من الخلاف مستحب. Avoiding difference of opinion is recommended. And that's not only an act of worship. The acts of worship, frankly, if you did something, if you wiped your whole head, that's good. That's between you and your Lord. Where taqwa is really tested, where can you act cautiously when it relates to the rights of others? That's like real taqwa. Okay? They say there's children's taqwa, but even a child understands that for me to worship my Lord better is better. Right? Even a kid can get that, right? If you tell a kid, give the toy back, it belongs to Bilal, that's much harder to explain. Right? To go beyond that, not is right, but share your toys with Bilal, that's even harder, right? So that's taqwa al-rijal, that's the taqwa of the accomplished one, is to be careful in matters of halal and haram. Right? And this is one of the things, right? And things like this, and rights and so on, that's ihsan. وإذا تزوج العبد حرة فنفقتها دين عليه. If a slave marries a free woman, bit of a problem because he has to provide for her, but he doesn't have any property. فَنَفَقَتُهَا, so providing for her is a debt upon him. يُبَاعُ فِيهَا, so he could be sold to pay it. So Kamal owns a slave named Jamal. Right? Jamal asked to get married. Owner says, go ahead. So he marries Jamila. Jamila says, great, you married me, but you gotta provide. She's a free woman. Jamal goes back to his owner, Kamal, says, sir, I need some money, I gotta pay the bills. He said, okay, but you owe them to me. So Kamal keeps a track of how much his slave owes him. Keeps giving him money to provide for her. Eventually, Kamal says, you owe me $10,000. Jamal, by definition, doesn't own anything because he's fully a slave. So he could be sold to pay the debt that he owes his master. Right? Or he could be sold to pay if she incurs the debt. If she incurs the debt, right, for her own provision, then, and this would be, of course, by the qadi. Right? She goes to the qadi, complains. She says, okay, you can take on a debt. It'll be owed by. He can be sold for that, unless the master saves him. So allowing your slave to get married to a free woman has implications, right? And there's some details related to that we won't get into. وَإِذَا تَزَوَّجَ الرَّجُلُ أَمَةً فَبَوَّأَهَا مَوْلَاهَا مَعَهُ مَنْزِلًا فَعَلَيْهِ النَّفَقَةُ. Right? If a man marries a slave woman and her master allowed her to stay with her husband in a home, then the husband has فَعَلَيْهِ النَّفَقَةُ. Then the husband has to provide for her, because the husband provision is only required if the wife is either living with the husband or willing to live with the husband, but he just says, I'm not ready yet. He says, well, I'm ready to stay with you. Then he would have to start providing for her, right? وَإِن لَمْ يُبَوِّئْهَا. But if the owner does not give permission for his slave, his female slave, to be living with her husband, فَلَا نَفَقَةَ لَهَا. Then the husband does not have to provide for such a wife in that situation. So we'll pause here and pray, and we'll be back in 5 minutes.
الله أكبر الله أكبر الله أكبر الله أكبر أشهد أن لا إله إلا الله أشهد أن لا إله إلا الله أشهد أن محمدا رسول الله أشهد أن محمدا رسول الله حي على الصلاة حي على الصلاة حي على الفلاح حي على الفلاح الله أكبر الله أكبر لا إله إلا الله
الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. الله أكبر. سمع الله لمن حمده. الله أكبر. الله أكبر. الله أكبر. الله أكبر. السلام عليكم ورحمة الله. السلام عليكم ورحمة الله.
Discussing that only the hospital of Quduri is not going to be because rich woman sell her husband as a slave if he's taken enough debts from her?
I thought they're slaves.
No, she's not his slave.
He's
She
her slave.
sells him as a slave.
Because
I'm not saying she owns him.
No.
She would sell him to someone else.
How would she tell me she doesn't own it?
No, so she's offering. Oh, you can sell. Okay, you can sell yourself, and I'll take the money for it.
I'll give you $15 if that's yes. Then that would be a valid way to reintroduce slavery.
She would not own him for a second.
No, so,
Then how
what
could she
she,
sell?
so she's not selling.
Okay, fine. He would sell himself.
He doesn't
You
own
can't,
it.
you can't declare yourself a slave.
Okay. Bismillah. We're almost done. Bismillah. Bismillahirrahmanirrahim. He talks about the provision of children. And this, of course, this is just ru'us al-aqlam. These are just very brief points. There's whole books written on providing. Okay? Small treatises, Kitab al-Nafaqat, and many extensive discussions. If you look in Quduri, for example, and other works, they discuss these extensively. And there's a lot of complications when it comes to providing, because all kinds of scenarios. So, like the Ottomans had a whole Qanun al-Nafaqat in the late Ottoman times and so on, because there's so many scenarios. ونفقة الأولاد الصغار على الأب. The provision for small children is upon the father, with two conditions, right? If they're poor and free. Because if the child is wealthy, then technically the parents could take from the wealth of the child to provide for the child in the things that are, but that requires the utmost of caution, because you cannot use more of that. And if the child is a slave, then the owner has to provide for the child, not the parent. على الأب, upon the father. لا يشاركه فيها أحد. No one else shares in the responsibility of provision. The mother does not have to provide for the child, the father must. Whether he's rich or poor. Now, if the father is poor, the mother says, I don't have to provide for him, then the qadi would command the woman to spend on the child, and then it will be returned. And then the husband would be obligated to return that money. I might mention in the commentary. Okay? كما لا يشاركه في نفقة الزوجة أحد. Just as no one besides the husband is responsible for providing for the wife. وإن كان الصغير رضيعا. So now a child is in the age of nursing, right? فليس, this is again one of those arguments that happens in the family, and you'll see that there's some discussion on this. So let's read the method first and then look at the discussion. فَلَيْسَ عَلَى أُمِّهِ أَن تُرْضِعَهُ. It is not the duty of the mother to provide for him. Now you'll notice something from the Lubab. That the Lubab does not unpack all the meanings of the method. So for example, what does the word radi' mean? Does the Johara mention what it means? Right? So this is where a commentary may not be as good as just marginal notes. Like sometimes you see, okay, I can just get the method of Quduri, and I can read from the Lubab, I can read from the Jawhar al-Nayyira. You just want to understand the method. The Lubab is excellent, but the Lubab focuses on the essence. He mentions what he focuses on in the beginning of the book. Right? There's three things, and these are the maqasid al-shurrah, right? But when the author tells you what they're doing, you can't blame them for what they did not take it upon themselves to do. Right? He says, right in the beginning, right? Right? He says, بِجَمْعِ بَعْضِ عِبَارات, to gather some expressions from the first page, 29 in R1. بِجَمْعِ بَعْضِ عِبَارات, to gather some expressions. تَكُونُ كَالشَّرْحِ, that would be as a commentary. إِلَيْهِ, and he gives three maqasid. لِتَفْصِيلِ مُجْمَلِهِ, to detail what is non-detailed in it. وَتَقْيِيدِ مُطْلَقِهِ, and to condition the unconditioned expressions in it. وَإِيضَاحِ مَعَانِهِ, and to clarify its meanings. So, he did not take it upon himself to explain the whole thing. He just make the meaning clear. So, that's where, so many of those classical marginal notes, right? Like Muqayyad al-Quduri, or the Indian, the Indian study commentaries that are put there for students just to understand the text are very useful, right? Because what is meant here by, what's the key word to understand this expression? وَكَانَ صَغِيرُ رَضِيعًا, right? رَضِيع, one should note, right, like a word, the fa'il pattern is tricky. So it can be used reflexively. Fa'il can be ma'na fa'il or maf'ul. Right? So we have no clue as to which one it's referring to. But there, if you open, and I'm pretty sure that's Muqayyad al-Quduri. So, because the fa'il pattern, like a radiya, this fa'il pattern can have one of, so rahim, right, is kathir al-rahma, right? The one who actively engages in me, that's bimana fa'il. Fa'il bimana fa'il. Allah is al-rahim, He is al-rahimu ala wajh al-kathar, ala wajh al-mubalagha, the one who is merciful, expansively. Okay. But fa'il is sometimes used bimana al-maf'ul. Alright? So al-Masih al-Dajjal, al-Masih, because he's mamsuh al-ayn, or he's mamsuh al-khayr, his good is wiped off from him. But Sayyidina Isa is called al-Masih, because إنه يمسح الأرض, يمسح الشر عن الأرض, because he wipes away evil from earth, or for other reasons. What does he say? Say anything?
No.
He doesn't? I'd be surprised.
I don't think so.
Okay.
It's kind of hard to tell. It's hard to tell with all the directions.
Okay. Are you used to it? Yeah. Pass it on to him. I didn't realize you lived just off the street that has your family name. Prince of Wales. I was amazed. So, right? So it's not upon the mother to nurse him. Why? And this is qada'an, in court. She says, I'm not going to nurse him. He takes her to court. The qadi will not do anything because nursing the child is like providing for the child. Who's obligated to provide for the child? The father. Right? But religiously should be told to do so. Right? Religiously should be told to do so. And now, this will go back to urf as well. Right? The things that relate to istikhdam, to serving, diyanatan, the wife is told to do it. Right? The wife is told to do it. The khidmatul zawj is serving the husband. The wife is told to do it diyanatan. Now, is it wajib or is it recommended? This would go back to urf. A lot of the books affirm that it is wajib in the Hanafi school for the woman to serve her husband, but the tahqiq of many of the leading Indian ulama is that this is bina'an ala al-urf, based on custom, that this would be reasonably expected. But the senior most ulama of the Indian subcontinent, the great living Hanafi scholars, been the case for several generations now, don't give fatwa on this position. They say it is merely recommended for the woman to serve her husband in the cooking, cleaning, etc. Because, and the reason they take this position, because there's a urf fasid, there's a wrong custom in our time of excessive expectations of serving from the woman. So an excessive burden. So this, there has to be a ta'deelul huquq, a returning to balance of rights and responsibilities. And this is discussed in various books of fatawa and so on. You can give some references outside. So is she expected to nurse or not? It also depends on the society. That is there a ready alternative, food, etc. You don't have to provide the best to your child. You have to keep your child alive and not cause the child great harm. You say, well, formula will make him grow 3 years. It won't. People, providing someone else's milk while the mother's milk is better. Well, firstly, those are not scientific arguments. And number two, simplest thing religiously, who nursed the Prophet ﷺ? Right? So it's not, and many of the Sahaba were nursed by other than their mothers. Right? So that's not an absolute requirement. Because people's temperaments are different, their physical capacity is different. Right? And this is when there are other people who can nurse the child, or other ways to feed the child, where it is in fact obligatory for the mother to nurse the child is إِذَا تَعَيَّنَتْ, if there's no one besides the mother who can feed them. They're traveling, no one else to feed the child, then no, I'm not going to nurse the child dies, obviously. But that's inexcusable. ويستأجر له الأب من ترضعه عندها, and it is the father's responsibility to hire someone who will nurse the child with the mother, عندها, in the mother's home. Because she says, I'm not nursing, so okay, then I'm going to have the child go to my relatives' home. No. the hadana, the custody of the child and the upkeep of the child is the mother's. She doesn't want to nurse. He has to provide for nursing for her, for the child in the mother's home, in his wife's home. فإن استأجرها وهي زوجته أو معتدته لترضع ولدها لم يجوز. Right? If the husband hires the mother to nurse her own child, so Zubaydah had a big fight. Because he kept telling her how he wants her to nurse till the last day of nursing requirement, etc. and all this. Zubaydah got fed up. Zubaydah, I have not nursed. I will not nurse. So he negotiated. He said, look, Zubaydah, I know you're in debt. I'll pay you $1,000 a month to nurse our own child. She agreed. That's lam yajuz. It is not permitted. Right? Because it is a religious responsibility she has, whether at the level of obligation or at the level of encouragement, to nurse her child. Right? Now, if she chooses not to nurse him because of the possibility of inability, and then it's difficult for her, it's hard, etc., she has that excuse. But if she's able to nurse, then that is a right the child has over her. Right? So you can't, and it's from the things entailed by the marriage. So you can't charge for it. As a contract, and they sign a contract that per liter of nursing or per nursing session, I will pay you contractually this much money. Okay? That's a pretty miserable marriage. If a marriage gets to that level, immediately say, look, if you don't urgently need to know the hukum, let me please send you to someone who can help you guys resolve your problems. Right? Because the husband hires the wife to cook for him, that's problematic. And if they do want to make this arrangement, they can do it indirectly. The wife said, look, it's hard work to nurse the child. I said, look, these days I'm giving you, a spending budget of $300. I'll increase it to $500. The spending budget. I'm not paying you for that. For the nursing, I'm giving you like a household budget, I'll increase your household budget. But please nurse the kid. Yes. Okay, but transfer the money in advance for the next 3 months. That's fine, because that's then, he just agreed to provide extra for her, for his nafaqah to her. He's not making a contractual payment for the nursing. Then can she then refuse to nurse after that? It's a separate point. Fuqaha have taught about all these possibilities. وَإِنْ أَنْقَصَتْ, and then وَإِنْ أَنْقَصَتْ عِدَّتُهَا وَإِنْ انْقَضَتْ عِدَّتُهَا, if her iddah is over. So Zubaydah ended up in divorce because of all the shenanigans. Says, I don't want to nurse the child, but they're no longer married. فَاسْتَأْجَرَهَا عَلَى إِرْضَاعِهِ جَازٍ. Then he hires her to nurse. He's still stuck on the issue. You have to nurse the baby. They're no longer doing that. We're not married anymore. You can't tell me what to do. Pay me. He pays her. She can accept the payment. But for him as well, if he spends on his ex-wife extra because she's nursing the child, that's ihsan. If he turns it into a payment, there's no ihsan, or there's much less ihsan. Because it just becomes mu'awada. It just becomes an exchange. Now the exchange may have a meaning of ihsan if he's being generous in it and so on, but you can do the same thing in many ways, some more virtuous than others, just by how you go about doing it and what intention you go about doing it with. And we see many examples of that in contractual law as well. وإن قال الأب أستأجرها وجاء بغيرها فرضيت الأم بمثل أجرة الأجنبية كانت الأم أحق به. Right? If the father says, I will قال الأب لا أستأجرها. If the father says, I will not hire her. This is what is this case related to? Divorce. They're divorced, right? So قال الأب لا أستأجرها. I will not hire her, meaning the mother. This is their divorce now. So he could have hired her to nurse the child. So poor little Salwa, nobody's hired, So Zubayr says, I'm not going to hire Zubaydah. But who's the child with? Presumably with Zubaydah, right? So what happens? So he brings another woman, Lubna's sister. Says, right? So then Zubaydah said, I will take that amount of payment. فَرَضِيَتِ الْأُمْ بِمِثْلِ أُجْرَةِ الْأَجْنَبِيَّةِ. Right? The mother, Zubaydah, says, I will accept the same amount you're giving to her. Right? كانت الأم أحق به. Then the mother, meaning Zubaydah, has more right to that payment. So you'd have to tell, Lubna's sister, I'm sorry, the mother herself has agreed to nurse. Now this is where, when people act without knowledge, they hurt themselves with Allah subhanahu wa ta'ala. In these kind of situations, you can't just wing it yourself. You have to act according to the limits of Allah subhanahu wa ta'ala. And also from the akhlaq here, that if Zubayr realizes that Zubaydah has the right to that amount of money, right, rather than Lubna's sister, then when he tells Lubna's sister, he should not disclose that he's paying Zubaydah. Because that could well be ghiba, because many people think she may want the money for whatever reason, but disclosing that could well fall under both backbiting and tailbearing, could hurt relations. It's disclosing something someone would want private. For whatever reasons, you don't want people to know. It's a private matter. And people make errors and those kind of things all the time. But if she seeks more than what the other woman was being paid, so Zubaydah says, well, if she gets 100 a week, I'm the mother, I deserve 125. لم يجبر الزوج عليها. Then the husband, the ex-husband in this case, would not be forced to pay the mother herself more to ward off harm. ونفقة الصغير واجبة على أبيه وإن خالفه في دينه. The provision of a child is obligatory upon the father, even if the child is of a different religion. How would that happen? Father became Muslim, for example. And the mother is a committed Christian, and the child is with her, and the child's Christian, for example. Still has to provide for the child. كما يجب نفقة الزوجة على الزوج. Just as it's obligatory, but this is required for the husband to provide for the wife. وإن خالفته في دينه, even if she follows another religion. Same principle. So that's the Kitab al-Nafaqat, and gives some of the guiding principles related to Nafaqat. There are of course a lot more rulings. Then you have the chapter on childcare, Adana, by which we will be finishing bi'idhnillahi ta'ala, the section on family law. So we'll stop there. We ask Allah subhanahu wa ta'ala that we strive to fulfill rights rightfully in good, and to strive towards virtue and excellence. بفعل فضله سبحانه وتعالى. وصلى الله على سيدنا ونبينا محمد وآله وصحبه وسلم والحمد لله رب العالمين.